Disclosing defects about a home to a home buyer can really be a double-edged sword. In spite of any possible opposition an agent may get from a seller, they must disclose this information to buyers as they are legislated to do so through the Real Estate and Business Brokers Act. When selling their home, many sellers prefer to hide serious defects from buyers. However, these same sellers take a different position when they stand on the other side of the fence as a home buyer. In the past, the general rule when you were buying a home was caveat emptor, buyer beware. The seller wasn't obliged to tell you whether the roof leaked or the furnace didn't work, or even if the house was built on a toxic dump. A buyer was supposed to figure all of that out for themselves. However, in recent years, the general trend towards consumer protection has included a change in the laws on the need for disclosure both by your real estate agent and you, the seller. As a seller, you may need to make written disclosures to indicate what you know about the condition of your home. The courts have decided that a strict application of the doctrine buyer beware would be oppressive and unfair to buyers, so the law provides relief in certain circumstances. There are two types of defects that may exist in a home: latent defect and patent defect. Patent defects are defects that are discoverable on a superficial inspection of the property by an ordinary purchaser. A seller does not have a duty to draw the purchaser's attention to patent defects. An example of this might be a large crack in the floor of the basement. If the purchaser fails to observe patent defects when inspecting the property, they cannot later complain about them. The doctrine of caveat emptor, buyer beware, applies. Latent defects are defects which an ordinary purchaser would not be expected to discover in a routine inspection of the property. An example of this might be a crack in the foundation floor that has been covered up by the seller with other flooring, hiding a potential structural problem if the defect was made visual. If the seller is fully aware of latent defects and does not disclose them to a buyer, and the defects are actively concealed by the seller, the doctrine of caveat emptor, buyer beware, does not apply. In this case, the buyer can ask for compensation for damages. How can a seller ensure that disclosure has been made to a buyer? In the province of Ontario, seller disclosures are still voluntary, but it's always a good idea to consider telling the buyer what you know. A major cause of post-sale disputes and lawsuits is defects and disclosures, and most disputes can be avoided if proper disclosures are made. Disclosure can be made easily through the use of seller disclosure forms called seller property information statements. These forms consist of a long list of questions, for example, whether there's been a fire, wind or flood damage that required repair, or even whether a death has occurred on the property. In the province of Ontario, it is legislated under the Real Estate and Business Brokers Act that if a seller has completed a seller property information statement, that this statement be made available to a buyer at the first time the buyer shows interest in the property. Many times, the seller's agent will add this statement as an attachment on the multiple listing service to ensure that they are in compliance with the Act. Moral of the story: sellers beware. More and more, courts are favoring the home buyer. A buyer who makes a buying decision knowing all the facts about the home is a happy buyer and limits the potential of future lawsuits.